Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, October 20th, 2022, which means this is the very last episode we will record before we record our Short Circuit Live in New York City on Wednesday, October 26th. So if you live in this New York City area, this is your last chance to RSVP for that show, which will be at 7 p.m. in the Financial District in Manhattan. So RSVP, ASVP, ASAP, and then you will get to meet my colleague Anya Bidwell and many others from IJ and our great guests who will be talking about the Second Circuit. And we've had a number of RSVPs recently. That's great. Keep them coming. A lot of law students, so it'd be wonderful to meet some more law students. And right now, of New York City area law schools, Brooklyn Law School is definitely winning. We have a lot of students from Brooklyn signing up, which is great. But other law schools in the area, you got to do what you can to make it up, because we'd love to see some of you too. We've got some Columbia folks who, some of whom I met a couple weeks ago at our Short Circuit Live there. Some from our friends at NYU. Fordham, we've got a couple who have a professor coming, and Cardozo, a professor from Cardozo, Alex Reinert, is going to be on the panel. But if you guys want to get close to Brooklyn, we'd love to see some more law students, and of course, some more lawyers, whether you're a clerk or a practitioner, or just a member of the general public. You definitely do not need to be a lawyer to come and enjoy Short Circuit Live. So we look forward to seeing some of you then. Now, today we have with us on the podcast, we have one guy who knows a thing or two about New York City, and that's Andrew Ward. Andrew, welcome back to Short Circuit.
Hey, I am very glad to be back. Thank you for having me on again, and I do love New York. It's a great place.
Well, fantastic. And another fellow who comes from a different part of the country than New York City, but is nevertheless a proud American, and that's Bob Belden. Bob, welcome to Short Circuit.
Yes, Anthony, thank you for having me. The people in New York City make dinner reservations after I have already gone to bed. So it's not for me, but I respect Andrew's choice to go.
Well, it's good that we're recording this early in the morning then. Well, Bob is still going. I'm sure he's been up for a while after his Indiana upbringing. Now, what we're going to be talking about today is actually pretty close to Indiana, and that's a couple cases from the Sixth Circuit. Now, one of them is about property rights. We'll be talking about that one later. But first, a case that is an IJ case that both of these gentlemen are attorneys for. Now, we were maybe going to do this case when it first came out. I think it was scheduling or something that we didn't talk about it on Short Circuit Live, but it is now time to talk about it because it is a cert petition, turned into a cert petition that is pending at the U.S. Supreme Court. It is an IJ case that some of you may have heard about over the last couple years. It's challenging the state of Kentucky's Certificate of Need law, and is Tawari versus Friedlander. So, Andrew, you've been working on this case a long time. A lot of judges have had things to say which contradict each other. It sounds like there's some other contradictions all over the country. And this cert petition is hoping to bring some clarity to all of that. So take it away. What's going on with the con law in Kentucky?
Yeah, and that's CON, Certificate of Need, that just so happens to spell con law. So what's going on here is a case about two men that just want to open a business, help their community, and the oldest of old boys networks won't let them. Our clients are two entrepreneurs, Dipender Tawari and Kishore Sepkota, who are really living the American dream. They immigrated to the United States from Nepal. They became American citizens. Dipendra opened up his own business as an accountant, and they live in Louisville, Kentucky. where, believe it or not, there's actually a pretty large Nepali-speaking population. There are tens of thousands of Nepali refugees that were forced out of Bhutan around the year 2000. It's a pretty long and not very well-known story, but a lot of those refugees ended up in the United States, and several thousand of them, believe it or not, ended up in Louisville, Kentucky, and live there today. And Dipendra has an accounting business focusing on that community. And he used to work actually at a home health agency. Those are people that send healthcare workers into the home, nurses, physical therapists, other aides to help with people with in-home care. He used to work at one of those places. And Kishore is himself a home health aide. And when they met, they really had this light bulb moment where they thought that they could really help do something for the Nepali speakers in Louisville. It's an older community. A lot of people don't speak English. There's a different set of cultural norms than, a lot of people that have been living in Kentucky longer. And they thought, we should open up a home health agency. We could hire younger people in the community who still know Nepali. It could interact with the older, sicker population, and everybody could win. And so they spent a ton of time planning that out. They filled out an application and everything was going great. And that is when they ran headlong into the con law. And what that certificate of need law says is that if you want to open a new medical business, certain kinds of medical businesses in Kentucky, you have to show that your business is needed. And the way you do that is that it's entirely based on how many existing agencies there already are. So the state takes a look at how many agencies there are and they say, there's enough. We don't need any more. And that's basically the end of it. They actually just use a mathematical formula that's simple, sort of grade school arithmetic, where they look at the statewide usage rates of home health. And then if a county has more people using it than the rates would predict statewide, new agencies get to open if there's a significant enough gap. And if not, they don't. And that's it. So
because we all know that supply and demand is equal everywhere all the time.
Yeah, there's no such thing. It doesn't examine need at all. Like Dipendra and Kishore were trying to meet a need. There are these people who don't speak the same language. They want, it would be better to give them care in their native language. But the law doesn't look at that. It doesn't look at whether the agencies are doing a good job or whether they're actually meeting any particular needs. It's just a calculation based on numbers. If there are enough, then no new businesses are allowed. And if there aren't enough, new businesses have a chance, but then they go into an entire trial-like program where the existing agencies have a chance to object to their existence by arguing that, no, we've got all the need. Like, this is covered. Why should anybody else get to do anything that would compete with us? Like, we've got it. It's basically like you want to open, this is, an example from the briefs, but like you say you want to open a hamburger restaurant and the government's like, no, there are already enough Burger Kings. Like, that's it. You're done. Well, maybe in a few places, 6 counties in Kentucky, when we filed the suit out of the 120, maybe you have a chance. But you are going to have to litigate against McDonald's for like a year. That's effectively what this law does. There was no calculated need in Louisville. And so our clients couldn't open their agency, Grace Home Care. And somewhat amazingly, the logic here, the government says, is that by keeping new people out of the market, by not letting them address needs that they perceive, this will consolidate business into fewer older agencies, and that will reduce costs, increase quality, and increase access to care. You might have questions like, how could banning more care possibly result in more access to care? But nevertheless, that is often how IJ's economic liberty litigation works. We litigate under something called the rational basis test, which we'll be talking about quite a bit, which actually means more like, can the government make something up that's not totally laugh out of your chair bad? And if so, that's how the law will be sustained. So my client sued about this, saying, we have a fundamental, maybe not. We'll see about that. But a constitutional
it's a technical term in this area.
Yeah.
So I think it's fundamental.
Our clients have an important and long-standing right to be able to earn a living. That's something that goes back hundreds and hundreds of years in English common law, American constitutional law, maybe all the way back to 1215 in Magna Carta. And this law is infringing it basically entirely for the benefit of the existing players. Immediately, the Kentucky Hospital Association intervenes to defend the law. They say we have a powerful financial stake in this. We will lose money if this law goes away. So, please let us participate in the case, which we think kind of proves our point. And then we have this bizarre situation where it pings pong back and forth. Every time we get a new judge, it seems like something totally different happens. So our first judge reviewing a motion to dismiss says this law seems terrible. Not only does it sort of not make any sense on its face, there is decades and decades of scholarship studying these laws, saying they seem to worsen all the things that they purport to fix, which isn't surprising because nobody would really think that concentrating service into just a few agencies is going to make things cheaper or more accessible or better. It really seems like this is just a protectionist thing to benefit the established players. Look at them intervening in this case to say, whoa, this helps us make money. And so he says, yeah, this looks like it could actually be unconstitutional under the rational basis test, which is a relatively weak standard of review where the government can kind of say anything plausible. And it's really the plaintiff's job to say, no, there is no possible way that this law could be doing something legitimate. That's how.
By relatively weak, you mean weaker than absolutely anything else. Is
yes.
that right?
Yeah, I mean, it really is. And this is eventually the subject of our cert petition. Different formulations of this test go so far as saying it's really if there is anything that the human imagination can come up with, as long as it's conceivable, we have to sustain a law. We go into discovery. There is a very strong record about how the hospital association lobbies for this law. The state follows the hospital association's recommendations. They have committees to try to open up the service to hospitals, but keep everybody else out. There's a huge academic record, including the federal government's position itself. The federal government has been against these laws since the 1980s, saying they don't lower costs, they don't increase access, they don't improve quality. And there's this close to unanimous, admittedly not 100% unanimous, academic consensus that these laws don't work. There's a woman who used to run Kentucky's con program said it's just sort of shenanigans by entrenched incumbents. And in response, the other side, hires a guy who says, well, I think it works. He does some analyses that don't meet the expert standards in federal court and aren't even close. And he says, well, I don't know. Maybe this could arguably do something. And of course, on top of all that is the common sense point that it is not going to increase quality of care to force people to get care in a language they can't understand. It's not going to increase access to ban the kind of care that they want. The state's response to that is they have an app.
Well, Andrew, it might be helpful to kind of steelman what the other side is saying. Can you think of what the best argument for one of these con laws is and why it's not persuasive actually?
Sure. So the very best case for the con law used to exist but doesn't exist anymore. The actual kind of not crazy justification that the federal government actually used to encourage decades ago was that Medicare reimbursed on what was called a cost plus basis. It would always reimburse depending on how much a provider charged. And so theoretically, a hospital could do something that wasn't needed. It could make a bunch of new wings and a bunch of beds that were just going to sit empty and factor that cost into the services it did provide. And then it would get reimbursed for that, even though there wasn't really a market demand. Congress changed that reimbursement scheme decades ago so that that rationale really doesn't exist anymore. Of the ones that exist today, there really aren't any good ones that apply to home health care anymore. in other cases, there's been discussion of possibly spinning off profitable services. Like you need to consolidate profitable and unprofitable services at hospitals because they have to provide care for free under federal law. And so maybe we shouldn't let someone open something new that spins off service. Whatever the merits of that, and it is quite likely wrong according to the research, there really aren't any good ones left that apply in home health care. We can talk about a little bit what the state said. But then we get to the next judge after discovery. He says, none of your evidence matters. This is the rational basis test. The state just has to make something up. And they've said, well, for example, economies of scale, right? Like if there are fewer agencies, we can buy like gloves and pencils in bulk. That will lower costs. So that's rational enough. I mean, nobody seriously thinks in the real world that having fewer of a business, fewer entities with less competition is going to lower prices, but it's make-upable. So the judge ran with things like that. Then we get to the Sixth Circuit on appeal, and then we get a totally different take on the law. Judge Sutton on the Sixth Circuit, who wrote the opinion, he calls it outrageous, that oral argument. He sort of berates the hospitals for saying, oh, you want to keep these guys out of the market. So that's you, huh? I hope this law doesn't end up killing people by reducing access to services. But
he also asks, right, where is the attorney general? Why isn't the attorney general defending this law, which he somehow didn't do?
The higher ups in the Kentucky government did just leave it to the cabinet of Health and Family Services. I couldn't tell you why, but they certainly weren't super interested up there in the SG's office or the AG's office in defending the law. But ultimately, Judge Sutton writes this opinion saying, as bad as this looks, it teeters on the edge of rationality, but we can't say that it's so irrational that we can strike it down in federal court. And even then, though, we're still talking about arguments that no one in sort of normal language would call rational, right? Like one thing Judge Sutton said was, well, these guys want a service that provides care in Nepali language to Nepali speakers. Who knows? Maybe if there are fewer agencies, they'll all be more profitable. And maybe they'll invest that profit in hiring people who speak more languages. So maybe you could rationally say that by banning a Nepali language agency, it will actually create more Nepali language services because the more profitable oligopolists will spend their money hiring Nepali language aides. That's the kind of thing we're talking about under the rational basis test.
I wouldn't really call that teetering on the edge. I think it's probably fell a long time ago, but that's what judges often say under the standard.
But that's what the Sixth Circuit said, and ultimately we decided to petition for cert. We think that this is really part of IJ's core mission, saying that economic liberty, the right to provide a living for yourself, for your family, to start a business, is something that the federal courts need to meaningfully protect. And that's what we're asking the Supreme Court to take on. Clarify the standard of review. Isn't this hyper-deferential rational basis test, and whether it's a meaningful rational basis test or maybe something else, as some amici have argued, it really needs to be meaningful. Because what we have now is a test where crazy things happen all the time. You have circuit splits over different aspects of this test about whether something like pure economic protectionism is or is not legitimate at all. You have splits where you just get these completely crazy results. Some courts saying if you want to sell caskets, not do anything related to funeral directing, but if you want to sell caskets, you can't be forced to become a funeral director. Whereas other courts will say if you want to sell caskets online, you still have to embalm 25 corpses for practice. You've got cases where people who commit like vastly worse sex offenses against children can be treated less harshly based on imagining pure hypotheticals that this is going to help children. There are a ton of crazy results. You have the Department of Justice arguing that space aliens could be invisible space aliens, unknowable space aliens could be the rational basis for a law. You actually it's gotten so bad that the courts actually split about their metaphors, where, you don't normally see a circuit split on metaphors, but there are two. There's a circuit split over whether or not the rational basis test is toothless. We have quotes saying that it is and quotes saying that it isn't. We also have a split over whether oh, I'm forgetting the second metaphor.
The second one is the rubber stamp.
Yeah, there's also a circuit split over whether this test is a rubber stamp or whether it isn't. And so it's really just a complete mess. And that mess matters because there is this longstanding right to be able to earn an honest living. It was taken away from my clients solely for the benefit of existing players. The agency that objected to them coming into the market was $1 billion hospital chain that couldn't possibly go out of business because these guys wanted to help people who are refugees from Bhutan.
So I have a couple things to ask. First, do either of you have a rubber stamp in your office?
Not yet.
I think rubber stamps are probably, like the dodo bird these days, well, except maybe at the front desk when you actually get physical mail. But I think when I started private practice in like 2005, they gave you a rubber stamp. I can't even remember what I used it for, but you would, move the date. And anyway, so that was a rubber stamp. I don't know about the rational basis test, though. It seems like a rubber stamp to me most of the time.
Justice Scalia used to say that he wanted a stamp that said stupid but constitutional. But what we really shouldn't have is a stamp that says insane but constitutional. And that's the way the rational basis test functions too often today, and that's what we're trying to change.
So I think if the cert petition is granted, a good idea for kind of a case trophy here would be a rubber stamp with the text that says not a rubber stamp, and that will be how we signify the victory here.
The rubber stamps, that's a good band name too.
It is what we're asking the court to take up. There is plenty of language saying this test is not a rubber stamp. There are plenty of cases in Supreme Court history where they've treated it as not a rubber stamp, saying, that argument's dumb. It makes no sense. We're not going to believe it just because you could make something up. Or there's no evidence for that, and we're not going to believe it when it's implausible. But then there's a whole host of other cases where they say, the limits of state power really are the limits of the human imagination. And if that's the case, everything is permitted. There is no thing that's too far for the government to do. And we'd like to be able to say that, no, there are really meaningful limits, and the right to earn a living means something.
And the other thing I was going to say is that if you guys out there, listeners, are interested in IJ's economic liberty work, which I know many of you have probably followed for a long time, this is an excellent summary of that. The cert petition in this case that we'll put a link up to, in addition to the Sixth Circuit opinion, if you want to give it a read. It talks about all these different rational basis cases and what they do, the roots of the right to earn a living, and it cites a number of sources that you can, if you want some deeper background in, that you can go and read. And so I commend it to everyone's attention. Also, in this case, there are, I counted 8 amicus briefs in support for the court taking the case, which is not a bad number.
Not at all. I'd actually say that with all, of course, appreciation and respect for our colleagues that filed amicus briefs, the most important person urging the court to take a look at this, I would say, is Judge Sutton, writing for the Sixth Circuit himself. He wrote this opinion saying we lose, but it came out on Valentine's Day, and it actually was a bit of maybe a love letter is too strong, but a like letter to some of the things that IJ has really argued for. He says that we lose because the test is deferential, but, maybe you guys have a point. This is not a law that he would vote for that he would vote for. It teeters on the edge of rationality, and maybe these guys have a point that the standard of review really should be higher. And he has this great section where he talks about, it's really hard to chop up rights into these different levels of review, and maybe we really should say that this is about liberty as opposed to property. It's bizarre that these guys might have more of a chance if they were under a different standard of review, if they lived in a different state, and that there are all sorts of things that the government does that affect things that are deeply important. He references IJ's probably most famous case, Kelo versus New London, when a woman lost her home for it to basically go to economic development for Pfizer. And Judge Sutton says that, these things really matter. And maybe this is something the Supreme Court needs to take a look at. We can't do that because we're one of the lower courts, but the Supreme Court can. And that's what we're asking them to do, basically. The Sixth Circuit said this is something you maybe want to take a look at. And for all, not just because of that, but for all the reasons we've discussed about all the problems with this test, it really is.
Anthony, what did you, I know you're a fan of state constitutions like many at IJ. What did you think of sort of the closing remarks in Judge Sutton's opinion, talking about constitutional causes of action at the state level?
Well, I appreciate, as I always do when Judge Sutton writes about state constitutions, that he said that there's this alternative, which is going to your state constitution. And of course, listeners may know that I've written a lot about state constitutions and how we should look to state constitutions to protect our liberties. But that doesn't mean that the U.S. Constitution should be ignored just because we have this other option, right? We have this other option for various reasons, one of which is that the U.S. Constitution just doesn't cover everything that we at the state level would like to have covered, or that citizens, when they put their constitutions together, would like to have covered. But it doesn't mean we should just ignore the 14th Amendment, which is the basis for your guys' lawsuit. So I don't think that should enter into how we interpret the U.S. Constitution. It's its own constitution. And maybe the Kentucky Constitution would give, a chance here, but this law has been on the books for a while, and I haven't seen the Kentucky courts doing anything for people like your clients. And so I think that's, it's a little bit of passing the buck there. You, as a federal judge, are supposed to be enforcing this Constitution, and we hope that the U.S. Supreme Court is going to put a little bit more emphasis in that job description that our Article 3 friends all have. Well, something else that our Article 3 friends all have is enforcing property rights in addition to the right to earn a living. And the Sixth Circuit also tackled that recently. This case just came out last week, and it's litigated by our friends at the Pacific Legal Foundation. It's Hall versus Meisner, and it's about this growing recognition of this problem called equity theft. So, Bob, it sounds like maybe a bit of a crime mystery, equity theft. So, what's going on here? This case it looks like it comes out of Detroit.
Yeah, it is a little bit of a mystery why counties and cities think they can do this, but I don't think the theft part is very mysterious once you get through the facts here. This is Hall versus Meisner, and what's going on here is that Michigan passed a statute called the General Property Tax Act, which allows a local government to initiate foreclosure proceedings on people who have tax liens. And so the best way to sort of understand this is probably by reference to the plaintiffs in this actual case. The lead plaintiff, as I understand it, had a tax lien of about $22,000. And it's kind of interesting the way that the court describes it. The tax lien is not just the unpaid taxes. It is taxes, interest, fine, like additional fees and assessments. So you're talking $22,000, which could actually be like a much smaller number. I'm not sure what the unpaid taxes were, but this statute allowed the county to take Tawanda Hall's home from her with nothing more than a petition to a local court. And the only way she could avoid foreclosure was to come up with all of the money to pay her unpaid taxes and all the fees. So doesn't seem like there's really an opportunity to litigate like, oh, do I actually owe these taxes? Is the proper process being followed? You just have to show up with a Brinks truck full of $22,000 and hope that they give you your house back. So the plaintiffs in this case brought among other claims, a Fifth Amendment takings challenge to this Michigan statute, saying the way that this statute operates, when you take Tawanda Hall's home and sell it and don't give her any of the proceeds, which is what this statute allows, you have taken sort of the difference in the value of her home and the tax lien. The delta there is what her sort of remaining equity in her home is. And she should be entitled to have that back. But this Michigan statute allows the county to say, well, we're just going to keep that. And so what happened here was the county took Tawanda's home, initiated foreclosure proceedings, got title, absolute title to the home, and then transferred it to the city where Tawanda lived. And that's sort of important because the county says, if we had sold the property, then sure, yeah, Michigan law says Tawanda can have the delta. We would have had to give her the proceeds of the foreclosure sale above her tax lien. But because we transferred her property to the city for I'll call it the face value, for the amount of the tax lien, we didn't conduct a judicial foreclosure sale. There were no proceeds. All we got was the outstanding tax obligation, so there's nothing left to give her.
We did such a bad job at making money off the house that we have nothing for her.
Right. But don't worry, the county might not be as into profit as the city, but the city had it figured out. The city handed it over to a private for-profit entity, which then turned around and conducted such a sale and got $308,000 for this woman's home. So the delta, I'm not a math guy. Listeners will check the numbers here, but it sounds like the city and this for-profit entity wound up with $285,000 left over, which otherwise should have gone to Tawanda. And if the county sold it, it would have gone to Tawanda. So
there are arguably more egregious examples of this sorts of thing in other cases too. I mean, there are cases where someone has had a tax delinquency of, a few dollars and the house is getting sold. And I mean, that's unfair enough. And it's why we have things like homestead protection. But they didn't just keep the few dollars. They kept the entire value of the house over like a few bucks in tax delinquency. And that's bananas is I think the technical legal term for it.
Just like a fundamental right, bananas is also a term of art in our profession. So the Sixth Circuit, Judge Kethledge is writing for the panel here, sort of runs through these facts and looks at the claims that the plaintiffs are bringing. And the real question here in this Fifth Amendment takings claim is, at a 30,000-foot level, the property interest that is protected by the Fifth Amendment is usually a creature of state law. And this Michigan statute is nothing if not a product of state law. And so it kind of gets to the question of, if there is an existing property right at common law or under state law, what can the state do to change or abrogate that property right? And so to establish that there is a property right at common law or state law, the panel starts in the 12th century, where all good opinions start, and runs through kind of the harshness of courts of law at the time, and how, if you were on some nobleman's land and you had your thatched hut and you fell behind on a payment and the court of law showed up that day and you were out doing something and you missed the session, the nobleman could just take your house, and that was it. And over time, courts of equity stepped in and said, oh, well, that's not exactly fair. We need to recognize some kind of remainder interest. And the panel runs through a few hundred years of English history on this in particular. And I mean, you have You have all the heavy hitters. I think you've got references to Koch and Hale and
Cook.
Mansfield.
I have to correct. I'm sorry.
It's
one of those trick pronunciations.
Anthony gave me an out here by mentioning that I am from Indiana, and so that's Koch to me. And
that's how Lord Cook was known in Indiana. I got it.
And Bank.
Yes, that you're not wrong about that. It is in Bank. But so after surveying the English history and sort of coming to the conclusion, that there is an equitable interest in this real property above and beyond whatever your lien is to somebody else, the person who's like trying to take your property to satisfy the lien. After acknowledging the English history on that, the panel goes into the American history and talks about our sort of uniquely American innovation of foreclosure by sale, which does what it can to kind of align the interests of the two parties here, the creditor and the debtor. If the creditor forecloses on the debtor's property, typically the creditor then has to go out and say, like, I'm going to try to get as much money for this property as I can. And that allows the creditor to have their lien satisfied. And it does what it can to protect the debtor's underlying equity in the real property. And again, in this section, I mean, you have Story, you have Marshall, you have Cooley. It's a very thorough survey of the American history in this area. And after running through that American history, the panel goes into what the Michigan statute does here and how it conflicts with that sort of 8 centuries of property protection for owners of real property. And at bottom, the best way to sort of sum up what is happening in the application section of this opinion is that Michigan law recognizes an equity interest for a real property owner in every single context, except for this one, where the county or a local government forecloses on a real property owner and does it to satisfy a tax lien. And so they look at the panel looks at a private foreclosure, like if a bank takes your house, they can't do this. They have to try to sell it and they have to give you the proceeds that are left over. And the court runs through like marital examples when you're dividing up assets in a divorce or mineral and timber leases. It's just uniform. You retain an equity interest except for when you have fallen behind on your taxes and Oakland County decides that they want your real property to satisfy.
You retain it except when the government's going to make the money.
That's exactly
so
right.
Weird, that coincidence.
That's exactly.
The analysis the Sixth Circuit does in the case that Bob is describing is really what we're hoping the Supreme Court does in the Kentucky Con case. I mean, there is centuries and centuries of history that's saying that there really is a meaningful common law and constitutional right to be able to earn an honest living. And if that's true and it means something, there's just no way that some bureaucrat doing like 5th grade level arithmetic can conclude a business isn't needed because of like usage rates statewide. And if the Supreme Court is looking at this through that framework, we really ought to be winning. And that seems to, if anything, be what the Supreme Court seems to be more interested in doing. There were several cases last term, and I'm definitely not expressing any opinions about whether they came out the right way or not. But the court really took this more historical focus about examining, what common law said, what early constitutional cases said. It's what the Sixth Circuit was happy to do in this case. And we think in a case like ours, it would show that we win in the Kentucky Con one.
I was going to say one other linkage to the Kentucky Con case that we've already talked about. Anthony brought up that Judge Sutton asked why the Kentucky AG was not there, sort of defending the law to explain, what was going on. And it turns out that in Hall versus Meisner, the Michigan AG did show up, but you sort of get the sense from this opinion that they the Michigan AG and the Kentucky AG are probably sitting somewhere wishing that they had done what the other did, because on page 14 of this panel opinion, the last full paragraph, Judge Kethledge notes that the Michigan AG showed up and warned about, quote, serious fiscal consequences, end quote, of ruling in favor of the plaintiffs here, who, to be clear, wanted to get back the value in their home that had been taken from them, like the value left over after the taxes were satisfied. The serious fiscal consequences to the state of Michigan, in the AG's opinion, required ruling in favor of the defendants here. And Judge Kethledge, I would be remiss if I didn't quote this line directly for the listeners. In that same paragraph, Judge Kethledge writes, "In some legal precincts, that sort of behavior is called theft." And he cites back to a dissenting opinion from a Sixth Circuit case in 2017 that I have not had a chance to review yet, but I'm hopeful that it's a colorful one. So yeah. Go ahead, Anthony. Sorry.
If your state's budget is dependent on theft, essentially, not taxes, not broad-based taxes, but taking people's homes and not giving them the equity out of them, then you have larger problems than just not being able to pay your budget. There's something else going on there, which is beyond what we're talking about today. The opinion's overview of the history of equity and law and equity, I commend to everyone's attention. And this is an often or almost always undertold story for people who go to law school, which is the division of law and equity and like what that means and what that informs us today. That you can get a little bit of a preview of by reading this case. One thing I think is really interesting to think about, and also it's interesting for, say, libertarians out there to think about, who maybe think about like natural law principles of what is property and liberty and right to contract and how courts should enforce that, is the property right at issue in this case, equity, that equity has created over the centuries. It's kind of a barrier on what you might say the freedom of the contract, because so if you have a contract, so that person with the thatched hut and the Lord, maybe there's like an imbalance there in the first place because he's the Lord after all, but they contract that, yeah, if you miss a payment, I get to take your house no matter how much you've already paid me, and I get to keep everything. And okay, let's put that in the contract. But then the courts of equity said, no, we're not going to enforce that contract. We're going to draw up these other procedures to protect that person. And then that gets embedded into the law of the realm, and then later the laws of the United States, unless you happen to be the government. So it's one, I think, example of how the common law, we often think about the common law is, much more libertarian than, say, the way that laws are structured in other countries or the way that we pass laws today in the States. But there's more to it than that. The common law can be complicated.
Yeah, although this one really, that is very interesting that you had this sort of like unconscionability principle that's arguably paternalistic, but not here though, right? Like this isn't a contract. Nobody's saying taxation is theft. Like the theft is the theft on top of the taxation.
Well, what I'm saying
when they don't give you the money back.
What I'm saying is the kind of deep definition of property, of what the property is has this complicated, I wouldn't even call it paternalistic. I think it's just like where the courts went in centuries past, but it has this kind of complicated background. And that kind of goes to like a bigger issue, which is why I think this case is so fascinating, is the federal courts often say that the U.S. Constitution does not define property. It just protects property from being taken or unreasonably regulated, and that property itself is a definition of state law. And here we have kind of an extreme example of the state saying, okay, but we're going to define the property.
Yeah, but it has its limits.
You don't get all this property. And so, like, what is when is it okay for, say, a state to change property law over time, and when is it a constitutional violation? And I think the best example of this is this long historical process is a way that it can change, but it can't change like all of a sudden through a statute coming in and just rearranging stuff.
And certainly not in litigation. One of the things that I most recognized in this case was a government defense of playing with definitions. We see that in IJ cases all the time. Basically, we say, you did this egregious unconstitutional thing, and they say, no, we didn't. And the reason we didn't is that we said we're not doing it. I'm dealing with this in a case right now in Texas. It's a free speech case. It is illegal for our client to tell people advice about their pets. Like if you say hey, should I feed my dog this? And he says yes, that's a crime under a literal interpretation of Texas law. And we say that's a free speech problem. Obviously you can give people advice. And Texas's response is, no, it's a crime. We said it was a crime. And obviously the First Amendment doesn't protect things that are crimes. So what are we even doing here? And this happens all the time in IJ cases. They just ipsa dixit say, we assert that we are not doing the thing that you accuse us of. And therefore we couldn't possibly be doing it.
Yeah, you can't redefine property that way. You can't redefine speech into conduct that way either. I should note, talked about a similar case at the Sixth Circuit, that an opinion that Judge Sutton wrote actually last year, where we had Ohio attorney Emily White on to talk about a case she did that was one of these equity theft cases from an Ohio example, and that short circuit, it was number 175. We'll put a link up in the show notes to that episode. So this is a continuing process at the Sixth Circuit. I know the Michigan Supreme Court has also been addressing this issue, and so we'll look forward to it developing in the future. But one thing I'm really glad we developed today was to talk about your guys' case at the Supreme Court. So best of luck. Do we know when the cert petition might get a hearing?
Mid-November is the first chance the justices will have to consider it.
Okay, so all eyes on that. And thank you guys both for coming on Short Circuit.
Yeah, thanks for having me.
All right, well, we'll see some of you next week at Short Circuit Live in New York City. But to everyone, in the meantime, I'd ask that you get engaged.